Kia ora, welcome to Saturday the 22nd of October 2022. For those that don't know why I start my videos with kia ora is a New Zealand Maori greeting. This means hello, good morning, good day. Also can be used as a see you later, have a good day, whatever. It's just basically just a colloquial New Zealand expression. So I'm not trying to pretend that I know very much Maori at all, because I really don't, sadly. Probably should remedy that, but this is just kind of part of the New Zealand way. So I'll add these expressions in from time to time. We had a busy day yesterday, tagging trees. So our forest looks a little like Christmas, and I'll see if I can, with apologies I'm limping because I've damaged my foot a little earlier this week, and it takes a little while to come right, but if I can hoof down here. Now of course going out and roaming around and doing stuff doesn't help. So you can see orange band, the sinister orange band on the tree. So we have some requirements on the property because we do not yet fully own it till we liquidate a hire. So we're kind of running two homesteads concurrently, I guess. And one of them is less than run, is more inhabited, and I guess you could probably say the same here as well. But anyway, for now, needs do what needs must. Transitory state. So the orange ribbon denotes trees that we can't basically take down without permission. That's the bottom line. So we've got the one caveat. We've got a couple, but the one, we're not planning on setting up a pig farm, so that one's not on the radar. We may have some pigs, but they won't be like a pig farm. But the tree diameters that we have a covenant that basically says nothing can be culled 15 inches or bigger, which is fine. But we needed to go out and mark what was without permission, I should say, cutting down without specific permission, unless we're clearing our home site. We still have a little clearing to do. We have like a minimum size that we can clear out, and we're nowhere near that. A maximum size that we can clear out, and we're nowhere near that. But we've got way more than we need at this moment in time. So anything else that we do will be focused around the house. So anyway, back to the ramble. So we just basically went out in a sort of concentric circle and pretty much marked all the trees yesterday. Roamed around, and anything else is pretty much subject to the rules of permaculture, I guess. So anything that's dead and diseased, we'll want to drop, and dying and diseased, we want to drop. We'll be clearing. We've got to go and review what trees we have. Probably in the next few weeks or month, because we're coming into winter and it gets a bit difficult to do that by bark only. It's good to have the leaves and anything that's dropping out of them, so we can actually more accurately determine what we've got and what we actually want to keep. Because we will be clearing them behind us here for gardens, as I mentioned. So yeah, caught up with a friend of ours, Bart, yesterday. Had a chat with him. Nice chap. So he is into milling and works with timber and trees in general. So we hope to catch up with him at some point in the next month or so. He has some ideas for dealing with the woodfall that we have behind us in a mutually constructive manner. So we'll look forward to having a chat with him and see what we can do to help both him and ourselves out in that respect. And I guess my ramble this morning, because I've said I want to try and keep these small. This one's for Bart as well, but it's also for another friend, Nathan, and anyone else who's interested in this area. And before I start this, IANAL, I am not a lawyer. If you are dealing with anything that involves my recommendation, money and legalese, you should always, seek legal advice, particularly here in the States, because we're pretty litigious here apparently compared to back in New Zealand. Well, it's changing there as well, I guess, but people tend to kind of sue on the drop of a pin here, just kind of for the stupidest things. It's just like, grow up here, come on. But anyway, I digress. Copyright and trademark is what I want to talk a little about. And as I said, IANAL, I am not a lawyer. You will see that IANAL reference as an acronym, and that's just what that means. It means like many pieces of advice that you'll see on the internet, and this is exactly in that same category. By all means, this is an opinion. Go forth and do your own homework. But here's kind of a very general gist on copyright and trademarks. So if you create a work that is your own work, you don't have to do anything special with regards to copyright. You automatically have copyright on it. It's usually a good idea to always include dates or preserve dates, particularly with electronic materials. Even anything that you're actually creating, if you've got the ability to put a date or a stamp on it, that's a good idea as well. If you're really paranoid, you can, of course, photograph or take, copies of your materials and get them notarized by a notary. All these sorts of things basically add credibility to your copyright. But you don't have to do anything special. If you create something that's original and yours, you have copyright on it. The end. Trademarks. Trademarks are more complicated. But again, at the most simplest level, you can claim trademark on anything original that you create, or if you think it's original, by simply just putting a TM, the little trademark symbol on the end of it. This is different from a registered trademark. A registered trademark, you've actually got to go and spend some money, put forward, copies of your representation, whether it's a logo, an image, or whatever presentation you're actually attempting to trademark. And they tend to be very specific. You can get variations on these things. And spend some money, and that will, as long as it's approved, then you get to use the little R in a circle, which is a registered trademark symbol. Okay, so that's the second category of trademarking, essentially. And then you get into patents, which are a whole different worm can. And patents, more often than not, differ largely because they're more about the process. Inventions are patented, ideas are patented, but they're more interested in the process of how this thing is created, and depending on how you put your patent together, and some people can get pretty clever and spend a lot of money on this. It can be relatively generic, or surprisingly generic actually, with some patents. I don't know how half of these actually get signed off on, but or you can be relatively specific. So if you have a really cool idea for something, and you think that no one else is doing this, them, and there's a particular process involved in doing this, and you want to basically patent the process, then by all means prepare to spend a lot of money. And I've never gone through this process, but patents, it could be 10k, 100k, depending on what you're dealing with and how many other patents are out there that may be similar that you need to basically differentiate against. That whole process is an expensive process. Advantages and disadvantages of all of these, just very quickly. And if you're interested in more on this, let me know in the comments below. And I'm happy to share at least my own experiences in the areas that I can, with again those usual caveats, IANAL. And I don't have experience in all areas because most of mine is through publishing and media, as opposed to physical objects and the like. But the same principles apply. The major difference is, well, actually, the major similarity between all of these is that if somebody tries to rip you off, you have to be prepared to challenge it from a legal perspective. And this doesn't matter whether it's copyright, trademark, registered trademark, or a patent. In the case of copyright, perversely, if you've actually, you've actually got a lot of protections when it comes to copyright, as long as you've done some due diligence and you haven't been stupid about it. Your work is your work, and that's the end of it. And depending on where you live in the world, there's your work is protected until your death and X years afterwards. And we all know about the whole Disney Mickey Mouse thing and Sonny Bono and extending all the stuff for 78 years and blah 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 blah. It's a whole bunch of crap. But anyway, it is what it is. So copyrights, you still may have to stump up and protect your copyright if you feel strongly enough about it, if you think someone has actually ripped it off. But usually takedown orders for content is usually sufficient under the Digital Copyright Protections Act. I think it's DCMP, if I get it right. I can't remember. It's been a while since I've had to do any. DMCA. So anyway, the other side of it is trademarks and registered trademarks. Again, you can claim a trademark, but you need to be prepared to defend that potentially in court. And if you have a registered trademark, I would go so far as to say you are expected to defend that. Because if you have a challenge to your registered trademark, you can have that struck off and or superseded. So there's potential legalities behind that. What that really means is, it's easy to stick a copyright symbol on stuff that you actually own and copyright. But if I was to put it in terms of layers of legal defense, in terms of expense, then obviously you're going up the food chain. Copyright, you're probably going to go to lower level of court, and you're probably dealing with less money-worthy objects, shall we say, potentially. And then up the food chain, you kind of get up to registered trademarks. Patents are on the top of the heap, because like registered trademarks, yes, you absolutely will be potentially in a place where someone challenges your patent or produces something that is scarily similar to yours. The idea behind the Patents Office, however, is that they're supposed to review other existing patents and see if there's any similarities, and therefore, issue the necessary paperwork to decline other people's patents and so on and so forth. But it's not a perfect science, and money lubricates the mechanisms of bureaucracy. So read into that what you will. I'm pretty sure that there's a bunch of stuff out there that's been patented, and usually if you have patents, you want trademarks associated with that as well, because the whole idea of having a patent is, if you're not going to use it yourself, is to own it and license it out to people for royalties to generate your income from that. So anyway, that's a very, 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 very rough overview. I can talk about this for probably, hours or so. if anyone's interested in this, you know, Dawn will be at the Self-Reliance Festival, and I'll probably be at the Self-Reliance Festival in March. If anyone is interested who's going to be attending the Self-Reliance Festival and thinks that this is a worthy topic for a discussion, yeah, by all means note that in the comments. I'm thinking about maybe doing 1 or 2 seminars on things, and it's easy to talk about stuff that you have experience with, you know, there's a lot of people wanting to do various things out there and really perhaps don't quite understand what they need to do and where they have to spend money and all that sort of stuff. But anyway, I hope that kind of, not really a ramble I guess, but I hope that kind of cleared things up for anyone interested. So yeah, I'll cut my ramble here. Let me know if you want to know more about this, learn a little bit more about it, or at least get my impressions. Yeah, and a little cloudy at the moment. I think I'm going to go and have a nice hot cup of tea and rest this foot some more because it's absolutely killing me. Small bones are surprisingly painful and annoyingly they take some time to heal, so probably going to stick an ice pack or something on them. Anyways, whinging pom comments aside, have a great day, have a great Saturday, and we'll ramble again tomorrow. Take care. Bye.